Good morning, members. Today we are back with another webinar. Today we are going to understand force majeure clause, which would be a very important aspect in the due to this lockdown. There would be so many problems that would crop up, and today we have to how to deal with the force majeure clause and to understand more. Today we have with us CS. Vivek Sadhale sir. He's going to take us through various aspects of force majeure clause. Before we start the session, I would like to briefly introduce him to you. Uh, Vivek Sadhale is a founder partner of Legal Logic, a law firm in Pune. Uh, he has bring uh, he brings 24 years extensive experience uh, in the field of international technology, commercial contract, IPOs, and some of the work related to venture capital investment also. He was working earlier with Persistent Limited for 13 and a half years as company secretary and head of legal and investor relations. He is currently working with Kirloskar Group, Bombay Dyeing, and Siemens also. He has received awards from international relation professional in India by Thomas Reuters in the year 2011. He has also received award as Surya Datta IT Excellence Award in the best category of CFO and company secretary in the year 2005. As you know, he is a fellow member of company secretary and he is also associate member of ICMA. So with this, we would like to start the session. Sir, welcome on behalf of Pune branch. Thank you for accepting our invitation.
Thank you so much,
Yes.
Abhishek, and thanks Karan and Prasad Bhalerao for inviting me here today to speak and putting this together at such a short time. And I know, these are testing times, so thank you so much. And
Right.
good morning to
Now,
all of you.
before we
ladies and
start, if you
gentlemen.
could just tell how the flow would be so that members would be in better position to understand of the program.
Sure, I will do that. And good morning, ladies and gentlemen. I'm very happy to speak today on this topic, which has kept us busy for last 2-3 weeks. If someone would have told me 6 weeks back that this is a topic that you are going to speak with chartered accountant community, people would have thrown stones at me saying that you've gone crazy. But here are we, and everyone's calling and asking questions. Can we invoke? What does this mean if this gets invoked? So I'm going to talk about force majeure and what we call as a doctrine of frustration under the Contract Act. I'll try and keep it business-wise, not try and use too much of legalese. Try and keep it as simple as possible. Karan is going to moderate the session today, so all questions that you put in, Karan is going to put it back to me, and I'll try and answer all of them to the extent we can. We have 1 hour time. So in next 55 minutes, my agenda is going to be to speak for 15 to 20 minutes on the topic, and then throw it open for questions. If we have more time, what me and Karan discussed yesterday is that I'll also talk about the employer and employee obligation at this time, and that's coming to the fore as well. You've been reading in media in terms of what is happening on the ground. You people manage finances for your clients, and there are tough times for the businesses. So what happens to the employees in this time with the Prime Minister making an appeal of not laying off people and what have you? So I hope I can touch on that, but I'll keep focus on the force majeure clause, which is the topic today. Abhishek, is that all right? And can we start with the topic?
Yes, sir, absolutely.
Okay, thank you. And Karan, what my hope is that we could, wait for the questions to be aired in next 50 minutes. I'll prompt you, and then we can start the Q&A.
Yes, sir. Absolutely, sir.
All right, Thank you. So, ladies and gentlemen, good morning again, and thank you for joining today. this is a topic which has come about, and which is something which we call as a boilerplate clause. And most of the times, including the lawyer community, would not pay heed to this particular clause. Or what happens is, when you are writing a contract and you get buried under various aspects of contractual back and forth and negotiation, force majeure is not something that people would keep a very, very clear eagle eye on. What I mean is that this clause gets templatized and is used from one to another without trying to understand what the implications of all of these are. Why do we make contracts? By the way, the contracts are usually made for bad times, right? In good times, everyone honors the contract because of the relationship. Everyone wants to be within the contract. Until the time you're making money, no one has any problem in terms of, even looking at the contract. But when I look at contracts, I look at it only when there are bad days, and what we call as, if there is a doomsday scenario, what will happen? Many a times when we are talking to clients obviously talk to, and I'm sure when you talk to your clients, you would receive this feedback as, let's not talk any negative, some of these things, uh, when it comes to termination, when it comes to some of these negative covenants in the contract, they may not play out as much as you would want them to understand. There's a concept of risk mitigation. There's a concept of risk framework that all of you as chartered accountants are very clearly advising your clients on. I'm not too sure if anyone looked at force majeure with that intensity that I'm sure each one of us would look at going forward. So it is because of the reason that hardly there is any discipline that has escaped the impact of COVID-19. There's just no one. Okay. There's just one company, which is DMart, which saw their share price rise for obvious reasons, but everyone else took a beating, be it a large or a small company, be it a large business or a small business. It is impacting all the legal and contractual framework, and with that, it is impacting relationship. Remember that contract is made to, as I mentioned a minute back, is to maintain relationship. And unfortunately, what's happening with COVID-19 is, while it's impacting contractual framework, it's impacting relationship as well. Now, with your employees, with your vendors, with your customers, with your landlords, all of them, you have something in your mind that, do I save cash flow? Do I pay? Do I not pay? How do I work on it? And then on top of it, you have social media, which paints all kind of pictures. So that's the backdrop in which we are looking at what we call as force majeure. In coming days, my sense is that the courts across world, including India, will be saddled with number of cases involving COVID-19, which is effectively on the manpower rationalization, which is retrenchment, layoff, salary alignment, and whatnot, closure of business units, disruption in supply chain, non-performance of contracts, calling off projects, implementation delay, and what have you. So the list is long. The questions that are coming to us are very, very intriguing, and not that I'm surprised that every day the questions continue to increase. And therefore force majeure has become a mainstay. It is of course about business, and it's not about legal at all. I'm of the firm belief that everything is about business and life, and the rest is subservient to it. So the force majeure clause is just one aspect of the overall business that you are looking at. And I'm told that one of the most searched terms on Google has been off late on the business side is force majeure, and I'm sure many of us on the webinar today are party to it as such. So effectively, what is a force majeure? The good news about it, and therefore a bad news, is that it is not defined in statute, which means like a definition of a director, which you find placed in Companies Act. You don't find force majeure as a word used under the Indian contract law or in any other legal statute that you have. So it's a British concept. This is also in another manner called as doctrine of frustration, and we're going to talk about both of those aspects in a while from now. You need to remember two words: force majeure and doctrine of frustration under section 56. Both are very, very critical from our perspective. India is a common law country, which means that the Supreme Court, High Court, what it decides also becomes law apart from the statute in itself. Now, what happens is with the case laws, you read the law along with the case law. Like we have several of those under the income tax, which Supreme Court and the High Courts have adjudicated on, and you are looking at something which is similar on both of these concepts. It's a French term. Usually we have Latin terms in law, but this is a French term. And as you would think, French laws are extremely difficult to understand, and so is this force majeure as such. The word force majeure simply means which is outside of control of the parties to contract. Okay, and in normal sense, many people would then call that many of things are outside my control, and the code does not look at it merely from this standpoint. Its meaning and applicability depends on the wording of the contract intended to anticipate unforeseen events and remedies for what happens on their occurrence, which means that you have to look at the circumstances along with the wording in the contract to determine whether the court would look at a particular aspect of force majeure being applicable to that contract or not. So people ask us that whether COVID-19 is a force majeure event, and our answer to that is that the force majeure event has to be looked upon to the contract that you're looking at, and then determine whether this could become a force majeure event in relation to the contract that you're looking at. You can't paint the whole landscape with one principle in this particular case, and especially when you have a contract with a force majeure clause, then it has a different connotation altogether. There are possibilities, by the way, that some contracts might not have visualized this eventuality or would have restricted wording of this particular clause, and therefore there is no explicit force majeure. It has to, rather, there is no default force majeure. It has to be an explicit clause in the contract. We have not had this magnitude of issues so far, which cut across the boundaries, and it is therefore not something that anyone has envisaged, and therefore obviously it is absent in statute books. Also, most of the contracts do not have a specific mention. Obviously, COVID-19 could not have been mentioned, but even this situation, right, as a principle embedded in the contract was not something that we find in most of the contracts as such. Now, coming to the impact of force majeure, you could look at an impact on the P&L or on the balance sheet. And again, in anything that you look at, end of the day, as you people would appreciate it far more than anyone else, that either there is an impact on the P&L or there is an impact on the balance sheet. What I'm talking about. So if you look at mergers and acquisitions event or an investment round which is taking place, and then you have contract signed but has not yet been closed, which means that the contract is signed and there are certain conditions to be completed by the parties before which the transaction is going to be consummated. It has an impact of the capital account changing, new money coming in, you're doing buyback, you're doing multiple things, so you're selling stakes and whatnot, shareholders changing. Now, with this material adverse change MAC event, many contracts are coming into a situation where the buyer effectively might just invoke material adverse change to the business and say that, look, I don't want to consume this particular contract, and that has an impact on your balance sheet. What Reserve Bank of India, which gave a moratorium of 3 months, and today there was a press conference, and there is a very clear mention by the governor very half an hour back saying that we're not going to have these account for NPAs for something which has a moratorium of 3 months of the EMI. All of those are impacting your balance sheet. So the force majeure event can impact your balance sheet, and obviously, many of the force majeure event are going to impact the P&L. Okay, and when you're looking at P&L, remember that you must look at both sides of P&L and not look at force majeure only from one aspect of it, where you are looking at controlling your expense. Remember that you are service provider, and when I'm referring to you, I'm referring to you as your clients as well included. Uh, when you are you either you are a service provider or you are a service receiver. So if you pull a force majeure on your service provider, think about its impact when you are receiver of the service and so on. And therefore, while I'm talking to my clients and people at large, I'm telling them that think before you invoke force majeure, because it cuts both ways. It will cut your expense side and it can cut your revenue side as well. Obviously, we are yet to see a complete impact of COVID-19, and it's just the start. And people are talking about you read today the TCS commentary, which talks about the impact running through the next year, and they are saying that the total recovery of the business is going to be in 2021. And obviously, the stock saw a very good reception with the transparent commentary that they provided to the market. Having said that, once you have thought about the impact on both sides of the P&L or balance sheet, as the case may be, you should be therefore in a better situation to determine whether you would want to invoke a force majeure clause or not. In any When we talk about any legal way of looking at life, there is a defensive aspect of life and there is an offensive aspect of life. When you are invoking a force majeure, you are effectively going offensive against someone, be it your service provider, customer, and what have you. Or when you are trying to defend, you are on the defensive side. So it depends on what side of the table you are, and therefore what stance would you take at that point in time. I'll also like to mention that there is a lot of social media interaction on February 19, 2020 office memorandum by the government of India, where it had clarified that the disruption of supply chain due to spread of COVID-19 in China or any other country should be considered as a case of national calamity, and force majeure clause may be invoked. And remember the words, wherever considered appropriate following the due process. So the words don't give a clarity whether the government intended to, or the other aspect is, can government force a force majeure across the board. So my view obviously is that it is specific to a particular question, it was specific to a particular situation, and we cannot paint it, again, as I said, one cut fit all kind of strategy. It applies in case of China or any other country. The term wherever considered appropriate seem to be vague and lacks finality. The memorandum is silent on the business deals between Indian parties, and the legal applicability of memorandum will be tested in the court of law, and we don't know how it will pan out. So, taking shelter under this particular February 19, 2020 memorandum is fraught with its own challenges, and my suggestion is to not advise clients only based on this particular particular circular that came, and everyone is sharing it with everyone without understanding the ramification associated with it. So that's just a quick thing in terms of what the landscape is. I'm going to talk a little bit about, what are the non-performance of contractual obligations due to COVID-19 outbreak. And I'm also going to talk about the test on how to determine whether the force majeure clause is applicable in a particular circumstances or not. So let's ask a question as to whether the non-performance of contractual obligation is excusable due to COVID-19 outbreak, right? That's the pertinent question that we are asking, that if there is a non-performance of the contractual obligation are you excused from performing because of COVID-19? So at the outset, all must understand that there is no universal response to this question. Okay, there's no one cut fit all strategy. Most of the contracts may include the force majeure clause to address the party's obligation under circumstances which are beyond their reasonable control. And then one of the parties may invoke this clause and say that, I cannot perform on the basis of force majeure situation. Okay. Having said that, you must make sure that you do the fact finding mission, and the fact specific analysis is required to understand the applicability and enforceability of this clause depending on what is the exact wording of the contract in question and the specific circumstances of the situation. When it is used in relation to contract, usually it refers to occurrence beyond the reasonable control of the party, and therefore it is important that it has to be explicit and not implicit in the contract. Now let's take a look at what are the steps to be taken to understand whether a force majeure clause, if at all it is present in the contract. How do you identify that? Now we are looking at two sets of contracts. One is a domestic contract and the second is a cross-border contract. So the first step in any contract while you're referring to, especially in relation to force majeure, is to identify the governing law of the contract. So the governing law is important because many a times when you're dealing with, say, a US customer or a UK customer or a Singapore customer, you would possibly have the contract being governed under those jurisdiction, and therefore the Indian contract law may not apply, and you need to then look at what is the local law and decide for yourself as to what works and what does not work in that jurisdiction. Assuming that the Indian Contract Act 1872 applies, remember that the Contract Act is 1872, but it's such a nice piece of legislation that even in these times, in these trying times, it has answers for everything. So Section 56, as I mentioned before, and Section 32, which is effectively the consequence, both come into play if the governing law is India. The second step is to identify and review the force majeure clause, what is explicitly stated under that particular clause in the contract. Once you have done these two things, you need to then understand what is the standard of performance according to the contract. So what do I mean by that? The force majeure clauses may vary in terms of how they codify the standard of impossibility of performance, which means that some clauses may provide for immediate termination, or some clauses may say that there is a temporary suspension and both parties are allowed not to perform during the time the force majeure conditions exist. And you therefore need to understand as to what are the consequences, if at all, the force majeure has mentioned in the contract itself, and the contract will run exactly according to what is expressly provided for in the contract. Okay. And then the most important question is, how are you being prevented from performing the contract? So think about it. If your client is in the ITES sort of activities, you can very well say that the customer possibly can work from home and deliver. So the courts go and see whether it is actually really beyond the control of the party to invoke a force majeure. Okay, it has to be really outside the. So, say for example, if the cost increases, if there is a hardship, the courts have said that we are not going to come and make any judgment because it is hard on parties to perform, that there is a force majeure situation. No, it has to be a situation where it is absolutely beyond the control of the party to perform the contract. So these are the four steps. Remember, I'll repeat it. One, check what is the governing law. Second, identify the clause and read the clause well. See what is the standard of performance according to the clause in the contract. And four, most important is to identify what are you being prevented from, and is that prevention absolutely beyond your control. So that's something which is a test that you would find in terms of looking at a force majeure situation. And the last, if you determine that all is in your favor, then should the notice be given, and what are the requirements of providing that notice that will conclude effectively if you are doing all diligence in terms of invoking or defending a force majeure situation. So I'll stop here for a minute and see if Karan has questions for me. Else I'll talk about section 56. Karan?
Sir, we have a few questions. I'll read out one by one for you. 1 second. Yes, sir. So the first question is, how does force majeure impact notice period if employee gave resignation before compulsory lockdown, as well as cases if resignation was given during enforcement of the lockdown?
Karan, I can't hear you.
Hello.
Yeah,
Vivek
Karan,
sir,
I
are you
lost
there?
you. Yeah, I'm there. I lost you for a minute. You said about the employees if they gave notice before the lockdown.
Vivek sir, are you there?
Yes, I can hear you well, Karan, but I'm losing you in between.
Yeah. Did you hear the question, sir, or should I repeat it?
Can you repeat that once, please?
Yes,
Thank
sir,
you.
please. Yeah. How does force majeure impact notice period if employee gave resignation before compulsory lockdown, as well as cases if resignation was given during enforcement of the lockdown? Over to you, sir.
Okay. Okay. So the answer to this is that employee contracts usually would not get into any force majeure situation. The employee contracts are governed by the labor law prevalent in the country, and the contract that you have with the employee. But the force majeure conditions do not apply in the employment scenario more often than not. But answering the question as to if the notice has been served before the lockdown was imposed, then at that point in time the notice would be in continuation of your contractual requirement, and based on the contract, if the person who's given the notice to the employer continues to adhere to that, he should be good and well within that particular contract. Should not be an issue. Second is, if you are looking at terminating any employee during the lockdown, as you have seen and have read number of notifications which have barred uh, any termination as such, and labor office is coming very aggressive against the companies, and we are dealing with few of those cases at this point in time, representing clients and helping them answer with labor department. My suggestion would be not to do anything which is effectively going to be questionable by the labor department and also create a bad press for you. So the answer is, during the lockdown, if there is any termination by the employer, that should be avoided to the extent the employer can, because of the notifications and the advisories that we have. But if the employee gives a notice and he wants to move on, it would be as per the contractual provisions under your employment contract. Correct?
Yes, sir. Should I go to the next question?
Please.
Yeah. For payment of wages or salary during the lockdown period, which category of them are excluded? At present, it seems all are covered.
That is correct. All are covered. The wording that has been used is loose. In the statute, the word employee has a different connotation to the worker, to the contractor, to the independent contractor, and what have you. But the notifications as well as the orders which we have seen are using all of these loosely, and therefore it has to be read in the interest of the employees, and therefore everyone, whether he is categorized as a blue collar, a white collar, a worker or otherwise, everyone will get covered as a protection to them at this point in time if we were to read it in the interest of the employees.
Sir, the same person has continued his question further. Should PL
Mhm.
and other paid leaves be adjusted against the salary pays?
So any change in condition to the employment can be done only with the consent of the employee. Okay. So one of the things very important to understand is that there is an employment contract, whether you do it as a letter or what have you, it's a contract between the employer and the employee. And the way it goes is that if you want to make a change, you can't make a unilateral change unless the other person has consented to it. It will not be effective and can be enforced. I'll give an example. In good times, if the employee were to move out without giving employer the notice, obviously the employer has a right to come after the employee. And in the same breath, if there is any change in the service condition, it is important for the employer to make sure that the contract is followed, which means that if there is an amendment required, that amendment is made and consent of the employee is taken. This consent can just be an email consent. It could be I know the signature is difficult at this point in time, electronic signature, not everyone is well versed with it, and there are challenges. The digital signature, not everyone would have it. So anything which acknowledges and consents by the employee, that's good enough from the employer standpoint to make that change. If you don't have a consent, then possibly there could be a breach of contract. Correct?
Yes, sir. Sir, moving on to the next question, one of the member is asking that he is keen to know in the in the context of agreements done with the government authorities.
Okay. Is force majeure applicable?
Correct, sir.
Okay. So again, as I mentioned, the 5-step test has to be followed in each contract. Assuming it's a government contract, India law would apply. And in that case, you need to read through as to what is the force majeure obligation. If the government contract is of an infrastructure nature, you're building bridges, you're building roads, and what have you, you will find that there is an elaborate force majeure clause. You must also look at the conditions of bank guarantee very, very carefully. There could be a performance guarantee triggered on the basis of what you have, and it might be important to understand the consequences of the delay because of the lockdown on your performance. And would that still trigger, because most of the contracts would have language notwithstanding. That notwithstanding pertaining to the bank guarantee could be really, really tricky. So you might want to make sure that you read that, you take a legal advice, because the trigger of bank guarantee is binary. The bank guarantee either is in the favor of the person against whom, or other for whom it is given, or to your favor. So you must be very careful in terms of what is the performance in the contract required, what we call as an SLAs, service level agreements, and accordingly look at the consequences, and not merely the fact that you give a force majeure notice and everything will be hunky dory. You must look at the contract holistically and then make a judgment whether you are protected and what steps you need to take, including intimation to bank along with the government if you are in a fix at this point in time in terms of performing the contract. Correct?
Yes, sir. So the next question is, what is the precedence followed by various courts internationally in history when cases under Ebola swine flu regime must have come up in determining the meaning for the term force majeure?
Okay, very nice, very good question. And there's very let's see, this is the first time that everyone on the planet is impacted. Okay, this is the all other pandemics, as the WHO had called, were relatively local and relatively not impacting everyone. This is like completely an unprecedented situation. Because of this, because of the fact that everyone is impacted, what has happened in the past may not be a good precedent for us to follow now. again, what has happened in the past with some of the pandemics that you just mentioned, current, the courts have gone and done the review in these five-step process, and we are assuming, as what I mentioned to you, these five-step process is what is the precedent by the court in terms of how and when it interpreted these force majeure clauses or doctrine of frustration in terms of their ability to grant relief or not grant relief. So the precedent has there have been one, but the question also arises is, is this insurance related aspect? Can I invoke insurance? Okay, one of the risk mitigating strategy on all contractual thing is that you buy insurance. And while the life insurance companies in India, as the association, have come back about 10 days back, they issued a clarification saying that we are not going to invoke a force majeure clause. Having said that, current, the liability policies which you and me take, which is like professional indemnity, errors and omission policy, D&O policy, any of those policies, if there is any claim because of this COVID-19, we are not too sure if the insurance companies will invoke on the liability insurance policies a force majeure clause, and how that will pan out. So there is no clear answer to this particular question, unfortunately. There are precedents, but this situation is different, and you can't use this the precedents exactly in the manner. You can take inferences in the manner I mentioned to you in terms of this five-step process, but beyond that, this is an unprecedented situation. It will unfold, and it will be very, very interesting for all of us to learn. Karan?
Yes, sir. So one more general question as such. My tenant is refusing to pay rent on commercial property. Is he
Okay.
right to invoke the force majeure clause?
Right. So again, we have seen several of these queries come in terms of landlord and tenant situation. Here is what I'm, I'll answer that question on the legal front, but on the force majeure, think about this: that this is not a permanent problem. This is a temporary problem. The force majeure situation, which people might say that there is a force majeure situation. Remember that you are going to go back to life in next 15 days, 30 days, 45 days, I don't know what, but for sure at that point in time, if you are in need of some of these things, what are you going to do? And therefore, as I mentioned, that this is about relationship. So before you talk about all of these situations, think about relationships first before you invoke. Now, coming to this particular question on whether landlord tenant situation can have a force majeure. So again, if you need to go back and see if your contract has force majeure, only then can you use that. The doctrine of frustration will not apply here, because you obviously are looking at it as a temporary measure. In terms of the lockdown is not going to be permanent. It will get lifted, if not today, tomorrow, if not tomorrow, day after, but at some point in time you will find that the lockdown is going to be lifted, and therefore this situation of being a permanently impossible to perform the contract will not happen. And therefore you need to be careful in terms of, if your contract has a force majeure provision and you want to invoke it, run that five-step process and then determine for yourself, can you do it or you can't do it, depending on whether you're a tenant or you are a landlord, both in tandem.
Thank you, sir. Moving on to the next question, sir. In many
Yes.
cases of contractors as well as for the professionals like us, there is going to be a request for lowering of agreed price or the fee structure. By any means, if the force majeure clause can be applied in deciding the price or fee reduction.
Right. Sure. So, these are commercial things, right? I mean, these apply in a normal situation. COVID obviously is forcing these conversations, and the social media, and, everyone as providing gyan in terms of conserving cash and what have you. So, some of these questions are coming to the fore, which are normal commercial questions triggered by a particular event. It has got nothing to do with force majeure. The force majeure per se is a temporary stoppage of something that you did not think at the time when the contract was being made that this situation would arise and make it difficult for you to perform the contract. But a change in price is a commercial call and decision that each person has to take. Else there are termination provisions, and there is a different service provider possibly waiting in the ropeway to catch the flight. So I think that question is not a force majeure question, but it is both parties to decide what is right for them to continue to be in the contract or go outside of the contract. Correct?
Yes, sir. Sir, from Limitation Act point of view, for counting any period of limitation, will lockdown period need to be excluded?
Now, what has happened is, assume that you are already in a sub judice situation where you have filed something, and there is a timeline within which you need to respond to something. The Supreme Court has very clearly said that all those limitation period will not apply. Okay, so there will be a concession given for the period during which there is a lockdown and during which there is a hardship. That limitation period will get extended to that particular time. So there will be a sympathetic view by the courts, given that Supreme Court has already come up in one particular instance in terms of the matters in front of Supreme Court and related matters, where the limitation will get extended to that way. So yes, I mean that's a very interesting question and thought. It will by all means looked upon with sympathy, and therefore, so for example, National Company Law Tribunal is completely closed. The courts are closed completely. You can't do much at this point in time. Certain courts are operating with video conferencing and what have you, but that there is a limitation in terms of technology and whatnot. We are just learning. Everyone is learning on the fly. So all of those will be considered, and I'm sure a sympathetic view will be taken for increasing the limitation period.
Sir, two related questions coming up. Number one, in what conditions under the COVID-19 scenario can the force measure be enforced? Number two, what is the application of force measure, or what is the implication of having applied the force measure?
So let me talk about the second question first, and the first question will get answered there itself. Is that the consequence when you have a valid force majeure clause enforced is the consequence as stated in the contract, okay, or in your notice. So, for example, if you invoke, let's talk about the government contract that you had seen. Rather, the question that came for the government contract, it's an infrastructure contract. You invoke force majeure, saying that it is becoming difficult for us to perform. At that point in time, the contract itself would have consequences. That one consequence could be both parties will not face consequences of non-fulfillment of their obligation during the force majeure period. So if say the force majeure period runs for 40 days, which is what this lockdown is, or 45 days or 60 days, then during that time frame, both parties are not being required to perform the contract. There is a temporary stoppage. The second question could be that the second question to answer is that if the force majeure condition continues for a longer time, then force majeure clauses have a consequence that the contract can get automatically terminated. So, for example, if there is an earthquake where there was in Bhuj in 2001, or tsunami in Chennai and related areas, at that point in time, it did not last beyond a particular time frame, and therefore, the termination didn't get triggered. But many of the force majeure condition, act of God, national calamity, they got triggered for a temporary time frame. So my answer to that question is the consequence after you have seen the force majeure and issued the notice is that there could be a temporary stoppage of the contract, and the obligation of the parties come to standstill. And if the force majeure conditions prevail for longer duration of time, there could be a provision of terminating the contract automatically because of the force majeure condition continuing to run for longer period as envisaged in the contract. There could be liquidated damages, there could be multiple different scenarios, but these are few things that in the normal force majeure clauses you see current.
Thank you, sir. Moving on to the next question. Loss of profit policies. How can now these be invoked by the business units?
Okay, that's another good question. That you need to look at what is the trigger for loss of profit policies. Okay, so for example, if there's a fire in a particular factory or in a particular office, then for the time that you don't use that, you are not able to use that particular place, and uh, all of that is a loss of profit trigger. But whether this, so for example, you and me can work from home, can we invoke a loss of profit because of COVID-19? Remember, what's happening is you can't go to office. There is obviously difficulty and there is hardship, but it is not impossible to perform what you could possibly do from home, from some other places. So it will be very difficult to invoke loss of profit policy unless the policy, while you took the policy, you have negotiated the policy in such a manner that anything that disrupts business and has an implication of more than X percentage could trigger in loss of profit policies being triggered only then. But I doubt, honestly, current on a practical basis, whether those policies will respond to COVID-19 situations.
Yes, sir. Sir, moving on to the next question.
Yes.
What are the procedural aspects of invoking this clause? Is there any standard procedure that needs to be followed?
Yes, so as I mentioned, it's a five-step process. I'll repeat that for everyone. One is try and see what is the jurisdiction, read the clause, read what is the performance expected, standard of performance, look at consequences, and then send a notice. So five-step process that you need to follow. Read the clause well. First step is to look at what is the jurisdiction, read the clause, look at what is the standard of performance, look at what are the consequences of force majeure, and then look at the notice clause. If you follow these five steps, you don't need a lawyer actually to send a notice out to someone invoking force majeure clause.
Sir, we have one last question as of now. With
Yes.
respect to the drafting of a force majeure clause in agreement, whether there can be an alternative clause of immediate termination of the agreement or an amendment extending the period of the contract.
Yes, both are possible. The Contract Act gives you a complete freedom in terms of how you would contract, and there are no restrictions as such imposed on the parties till the time the void contracts. The contracts have provisions which are void under law, and there are very few things as such. So the answer to the question is yes. If there is a force majeure condition, you can have a consequence that it would immediately terminate the contract or increase the duration of the contract, where the limitation period question is in similar way to look at, or you had a certain time to perform, the time actually increases by the time of force majeure. So 40 days lockdown, I get additional 40 days, or 40 plus grace, 40 80 days to complete what otherwise would have run in a normal course of time. So all of those are possible to be put in the contract. Remember that going forward, I'm sure what triggered after 2008 downturn, financial market downturn, and I used to work for a technology company as general counsel at that time, and we started to see one page, two page insurance clauses come in. And I anticipate one page, two page force majeure clause to come in. Obviously, over time, it's now 12 years to that event of 2008. We don't now see the insurance clauses as large as those in 2008. But I anticipate force majeure clauses to come in vogue at this time. And they will die down as we go forward. As they say, public memory is very short. So this will be the flavor of the day. And with something else, it would move on. We won't even remember COVID-19 after few days. Correct. So that's how you should look at it, and I think we should be okay.
Sir, I guess in continuation to this thing, we have a question that who has to initiate the action? Any party or the party who has suffered loss, to be specific.
Sure. So, there are two aspects to it. Say, for example, uh, I'll give without naming the client, we have a client who's in a gear manufacturing business. And what we suggested to them is to put their customers to notice, not invoking force majeure, but just to say that we have a lockdown, and then, our deliveries may be delayed because there are delivery specific requirements and consequences of not fulfilling them. So you are effectively invoking those clauses to say that, look, we are putting you to notice, saying that there might be delays and they are not in our control at this point in time, because we cannot reach factories have been asked to be closed, and there is nothing that we can do at this point in time. Point number one. That's from a supplier's perspective. And the from customer's perspective, in the same way, they would possibly say that, look, even if you supply, I can't use what you supply, and therefore don't supply during this time period, right? So it cuts both ways, that some people might have inventory and they may have an ability to transport. I don't know how, but there could be theoretically a possibility. For example, after 20th, certain sectors open up. Certain sectors may not be able to open up, which are in hotspot and containment zone. One person who has ability to produce, but the person for whom he is producing is unable to consume. At that point in time, the person who's unable to consume, who's the customer, might say that even if you can produce, don't produce because I can't consume it. That is his raw material. I can't consume it for my end product and can't sell it. So I'm giving you a notice that there is a situation at my end. It might have eased at your end, but it continues with my situation, and therefore do not produce. So it can be, the notice can be given by both sides depending on what you are trying to accomplish at this time, when you give that notice. Correct.
Sir, this particular clause that we are talking about, if it is not mentioned in the agreement, so
Yes.
one of the members is asking, would you suggest it to add it now if the parties agree?
Of course, if the parties agree, you can do all that you can do. But I must also say that it's not end of the world if the clause does not exist, because section 56 of the contract law talks about a doctrine of impossibility, and that doctrine of impossibility is something which is very critical under law, and the courts have said that it has to be absolutely impossible to do the act. Okay. So what it means is that if you are able to provide a satisfactory answer to the court, and the court will decide how much time it takes, and all that is a good question to ask. But the difference between a force majeure and impossibility is, when you say that it is impossible for me to perform the contract becomes void and gets terminated then and there. Whereas when you invoke force majeure, it is a temporary measure and may not lead to termination as such. So remember very carefully whether you are invoking a temporary provision or you are invoking something which is an impossibility. Obviously, because it leads to termination, the courts have said that mere hardship on a particular business will not trigger an impossibility. So, for example, what can be an impossible event? Suppose, tomorrow you're saying that pick your choice on a performer. Shah Rukh Khan was to go and perform in a wedding. Okay. So, I don't know, Karan, you are married or not. He comes to your wedding to perform, and because of this lockdown he cannot come because it's just he can't move. that's an impossibility. Okay, you can't have Shah Rukh perform in some of these situations. Those could be impossible contracts. You could say that he could do it on video, like what we are doing as webinar. That still may not serve the purpose, and you say that no, I was trying to pay him premium because he was live and in front of everyone. Those contracts could come under impossibility, which have personal flavor to it, but something which has you could work from home, you could arrange from something somewhere, those courts will not grant as impossible to perform. So that's the difference between, if you don't have a clause in your contract, check if you could be in an impossibility doctrine, and you are okay to terminate that. If you are able to invoke and you say that it is impossible, it will get terminated immediately. So that's the way to look at a doctrine of impossibility versus force majeure clause. Correct.
So few more interesting questions which have come up
Yes.
right now. One of
Yes.
it is, can the force majeure clause be clubbed with the variation clause?
Yes, you can. Absolutely, you can do that. I mean, all of those, as I said, the contract law gives you complete freedom. You can have a force majeure tied to variation, which means that there is a consequence where the variation in the contract is related to force majeure event. Absolutely, you can do that. You need to word it well. You need to make sure that the intent is captured in the contract. But as a principle, yes, of course, you can do it. Correct.
Yes, sir. So moving on to the next question, what remedies can be available if this clause is enforced by other party where it actually should not have been enforced?
Come again. Sorry, I missed that.
What remedies can be available if this clause is enforced by the other party where it actually should not have been enforced?
Okay. So what it means is, then you are in dispute. So for example, you invoke force majeure and I say that this is not a force majeure event, then we are not in agreement with each other's view, which means we are getting into a dispute situation. That dispute situation can be cured by way of a mediation, if there is one, or an arbitration or a court process, depending on what the contract provides for. But and therefore, when I started, I said that I anticipate a host of these situations come to the court, because many parties who invoke force majeure uh, situations in the contract, and someone who is impacted with it resists that, would effectively mean that there is a dispute between the parties, need to be settled per what the dispute resolution mechanism stated in the contract. And if there is none, then you can go to the court and enforce your right under the contract.
Thank you, sir. Moving on to last two questions. In case if a company or an entity suffers tremendous loss due to the COVID-19 situation, can they terminate employees on the ground that there are no sufficient funds for making any payment?
Right. So, I mean, we've seen this on social media. We are seeing it by clients, and this is a real issue. And everyone is expecting, like what you saw in the US in terms of wage subsidies coming in. And one of the ways that many countries have done, including Canada, UK, US, is that they are saying, if you continue to employ people, we are giving you soft loans, and they will be converted into grants if you continue to show the same level of wages that you gave last year, as the test will be after 1 year's time. Okay. In India, except for one provision where the PF is going to be borne by the government for those employers who are less than 100 people company, and those 90% are drawing less than 15,000 salary. Those have been provided a relief that the government will pay both the employer and the employee contribution. Beyond that, there is nothing that has come as a direct tangible benefit by the government at this point in time. Therefore, there are questions that while there is a lockdown which has been imposed and which is creating hardships on the businesses, and if they don't have money, as to how do you enforce the why and how is the order enforceable and things like that. There's no clear answer at this point in time, and the businesses are therefore taking their own way of dealing with it. If you don't have money, you don't have money. But my sense is, before you initiate any of these for your clients, if they come to you, be very careful in terms of looking at what is the best way of dealing with this, with the Prime Minister's office asking for clarity in terms of what's happening with the employees as such in today's economic times as well. Those who are fortunate to get it at home, or just go to the web and see the Provident Fund as well as the ESIC department has been mandated to go and check what's happening on the PF deposits and the ESIC to determine the real impact in the organized sector. So that's being tracked. So be careful in terms of invoking termination in these times when there are orders to contrary.
Okay, sir. Sir, two more questions. I guess we would be taking those considering the time. First one is, in case of one of my clients who is in infra project of PWD,
Mhm.
PWD has allowed to do the work, but my client is not getting any material and labor in this period. So how will
Right.
this clause be enforced?
Right. I mean, my suggestion is to inform the PWD department immediately, if not informed as yet, and be very clear in terms of the difficulties that you have and what is, and one of the ways we are saying is that if, say, for example, PWD is able to arrange for the material from their own way, you should say that we will be most happy to perform if you remove those hurdles, which are actually real hurdles in the scheme of things. So if your customer, in this case PWD department, is able to remove that hurdle, and if you are willing to perform your job, you should state that in a positive way, which effectively also means that you are putting them to notice, saying that there is a hardship. While you are willing to perform your contract, because of these hardships you are unable to, and that would serve you in better stead if at all PWD at a later point in time comes that you are not able to perform the contract. So all of these defense mechanisms and risk mitigating factors will help you should this go in any kind of litigation at a later point in time. Correct?
Okay, sir. One last question. Electricity boards are charging fixed load charges. In any case, will all these be covered under force majeure during this lockdown?
So what I have read, and again, I don't know, I have read this not deep enough, but what I have read is that the fixed charges are being suspended, not, or rather, in other words, deferred for next 3 months or so. So what I hear is the certain consumers, industrial consumers, would get the bill without the fixed charges from the electricity department. But again, this is something that I read very quick. I may not be accurate in it, but that's a relief that the department is contemplating, or the bills that we receive or would have received, would have those fixed charges waived for a certain period of time. I step back, not waived, deferred for a certain period of time.
Sir, these are all the questions for the session today. So, sir, over to you for if anything you would like to share.
Yeah, so thanks so much, Karan. I wanted to again thank you, Abhishek and Prasad Bhalerao, for putting this together. My last two sentences is that think about relationship. This will go away, but the relationships continue. So the judicial interpretation will come over time. We don't know, and therefore, whether to take the risk or not is something that you need to be very, very careful about. If you have any specific questions which are to your businesses or to your clients' businesses, feel free to drop an email to me. My email address is vivek.sadle, that is my name dot surname, at legallogic.co.in. And very happy to answer any questions that you have related to this or anything on the legal side.
Sir, is that the correct email address which I have put up?
That is perfect. Thank you so much, Karan. You're amazing.
Thank you so much, Vivek sir, for sparing out your valuable time today morning with us for approximately more than an hour now. And thank you so much for all your inputs and answering those questions, being patient to hear them enough, and answering those, giving your valuable responses. I'm sure that this particular clause, which we were not aware of or not aware about its implication per se, so now we are aware about those things, and we'll be able to at least understand this clause and its repercussions and consequences. Thank you so much, all the participants, for being here. And also, I would like to thank the Kolhapur branch of ICAI. The chairman CA Anil Chikodi sir was supposed to be here with us today, but due to some technical issues, he was not able to join. So, thank you so much, Kolhapur branch, for jointly hosting this particular webinar. And once again, thank you, Vivek sir. One important announcement I would like to make it for our members watching this webinar. I have pinned up a comment. Pune ICI conducts survey on CA firms' adaptability to work from home. So at Pune ICI, we are just trying to have this survey in order to understand how exactly the firms are responding and how equipped they are for this particular situation. So that we can, if we get some opportunities, we can represent these particular inputs. So I would like to request each and every one of you to please fill out this particular survey, especially for those who are into practice, so that we can take it forward. Thank you so much, Vivek sir. I guess we are good to conclude.
Thank you so much. Thank you. All the best.
Yes.
Bye.
Thank you, sir. Yeah. Bye.